State Code 59-29A defines a sexually violent predator as any person who has been convicted of or charged with a sexually violent offense and who suffers from a mental abnormality or personality disorder which makes the person more likely to engage in repeat acts of sexual violence. Civil commitment of these predators is an ongoing debate and argues the rights of the predators versus the rights of the citizens. Does civil commitment after a prison sentence has been served violate the double jeopardy clause of the Fifth Amendment? And should free people have to worry about habitual predators walking the streets free? Today I would like to discuss a Supreme Court case that involves the above state code and also both sides of the debate. In 1996, the Supreme Court decided the case of Kansas v. Hendricks. In 1994, Kansas used the Sexually Violent Predator Act to civilly commit Leroy Hendricks. This act defines the processes that the state must follow for civil commitment, and Hendricks was the first person they used this act against. Now, Leroy Hendricks molested 12 children over a span of 29 years. His victims ranged from boys to girls aged 7 to 11, and there was never more than 1 year between his release from prison and his next offense. He claimed that this violated the Double Jeopardy Clause and also ex post facto laws. The Double Jeopardy Clause of the Constitution states, "No person shall be subject for the same offense to be twice put in jeopardy of life and limb." And Black's Law Dictionary defines ex post facto laws as laws passed after the occurrence of a fact or commission of an act which retrospectively changes the legal consequences of such act or deed. The Supreme Court, in a 5-4 ruling, upheld this act as constitutional. They stated that it does not violate the Double Jeopardy Clause since previous charges are used solely for evidentiary purposes, either to demonstrate that a mental abnormality exists or to support a finding of future dangerousness, as Justice Thomas stated in the opinion of the court. It also does not violate ex post facto laws, as it does not enforce punishment in a criminal sense. So we'll look at one side of the debate. Many agree that civil commitment is a great way to protect from potential victims. In 1973, a 13-year-old boy by the name of Paul Martin Andrews was kidnapped and chained in a makeshift underground box. Andrews stated, "I was abducted by a sexually violent predator named Richard Osley, who had been twice convicted for sexually assaulting young boys." This does have a happy ending in that he is now an advocate for sexual rape survivors and is also an activist to uphold Kansas laws for civil commitment. But what happens when the case does not end so nice? In November of 2003, Drew Soden, a 22-year-old college student, went missing from Grand Forks, North Dakota, and her body was later found in Minnesota in April of 2004. She was found nude with her hands tied behind her back and had been sexually assaulted and beaten. In 2006, Alfonso Rodriguez Jr. was convicted of federal murder and sentenced to the death penalty. He had previously spent 23 years in prison for attempted murder, attempted kidnapping, and previous rape charges. He was considered a level 3 sex offender by Minnesota State prison officials, but yet was not considered for civil commitment and was released just 6 months before he kidnapped Drew Soden. Support claims that these cases and also the hundreds of thousands of sexual assault cases that are committed each year could be prevented by civil commitment. But what about the side that argues for the rights of the criminals? And they claim that this is still a violation of their rights. One major point of the opinion of the case of Kansas v. Hendricks is that civil commitment is not criminal because the state has represented that an individual confined under the act is not subject to the more restrictive conditions placed on state prisoners, but instead experiences essentially the same conditions as any involuntarily committed patient in a state mental institution. In his dissent, Justice Breyer argued, certain resemblances between the act's civil commitment and traditional criminal punishments are obvious. Like criminal imprisonment, the act's civil commitment amounts to secure confinement and incarceration against one's free will. People also question the treatment of these prisoners, when it is provided, and to what level of standard is the care. Justice Breyer stated, yet the act did not provide Hendricks with treatment until after his prison release, and only inadequate treatment thereafter. as is the case with almost every single criminal that is in civil commitment. Hendricks was also concerned about the indefinite time span of his civil commitment. The opinion of the court claimed this fear was misdirected, as the confinement's duration is instead linked to the stated purpose of the commitment, namely to hold a person until his mental abnormality no longer causes him to be a threat to society. As of 2007, at the age of 72, Hendricks was still committed in a state mental hospital. And so the question comes down to which is more constitutional, the rights of the prisoners or the rights of the free people? The case of Kansas v. Hendricks, and also both sides of this debate, leave great evidence to sway this decision either way. Supporters claim that the necessary and proper clause of the Constitution, which states, Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, would give the government the right to create laws that would protect the safety of the free citizens. And then arises the question, are these laws allowed to violate parts of the Constitution, such as the Double Jeopardy Clause, just to maintain these protections? Thank you.